So we all remember the George Zimmerman trial. Well, there's a similar one taking place in Florida as we speak. A white software developer is about to go on trial for the death of a black teenager, very similar to the George Zimmerman trial. Michael Dunn, a 47-year-old, basically fatally shot Jordan Davis in 2012 outside of a Jacksonville convenience store after arguing over loud music that Davis and his friends were playing in their SUV. Dunn says he fired multiple shots in SUV after teenagers threatened to kill him and one raised a shotgun. Dunn was arrested the next day, but he is claiming the stand your ground law. The difference between the two cases is that Zimmerman was Hispanic and he was acquitted of the second-degree murder, but Dunn is Caucasian. So we'll see what happens in this case. There's a lot of folks that are watching this case very intensely because this case is another example of where the stand your ground law has caused the death of another black boy by a Caucasian man, because it basically, like I've said this on the show before, the stand your ground law is open killing season on black men by white folk. Point blank, period. Because there's very few black people that have ever gotten off on stand your ground. Melissa Alexander wasn't allowed to get off on stand your ground, and she was just standing her ground. But Michael Dunn went out there. These kids were minding their business, playing loud music. First of all, he had no reason to go up to them and say, hey, turn your music down, because it's not his house, nor is it his property. It's a convenience store. Unless the convenience store manager says, hey, listen, the music's too loud, I need you to get off my property, or I'm going to call the police. Michael Dunn's a random citizen who decides that he's going to walk up and be some sort of regulator, some sort of wannabe police officer, a Project Save-A-Ho, and in the process of doing that, he caused the death of an innocent black man, Jordan Davis. We'll see what happens in this case. We'll be monitoring here on the Fowler Show. We need you to do the same, because this is one of those things where unless we bring attention to these type of laws, we'll never change them, folks. So we've got to get up. We've got to get active. We've got to get engaged here, because this is about the lives of our black men and boys, and we got to do something about it, y'all. We really do. And the next story for you. At least 26 children or teenagers died in the state of Florida because of the stand your ground law. The Michael Dunn trial, like I said earlier, starts this week, where a fatal guy was shot by where he basically shot a 17-year-old for no reason in particular. But Michael Dunn is just the first in many African-American youngsters who were victims of the stand your ground law in the state of Florida. The youngest was a 19-year-old, Shadava Jenkins, who was killed in the crossfire in dispute which the defendant unsuccessfully raised the stand your ground law as his defense. Then there was 18-year-old Daniel Armour, who was stabbed to death by a 31-year-old legal guardian. And once again, Grant, the legal guardian, was given the stand your ground law immunity by the judge. In another situation, 19-year-old Christopher Arroyo was shot by Norman Borden, who said he was walking his dog when three men in a Jeep shouted out threats at him and warned that they had bats as weapons. So what this guy did, he went into his house, he came back out armed, he told his friends to leave the area, and then he just opened fire. And the judge denied his stand your ground motion, but he was acquitted by a jury of first-degree murder, similar to George Zimmerman. In another case, the case of Carlos Maestro was shot to death after he and his 16-year-old friend approached Thomas Barker jogging. One took a swing at him. Thomas responded, "You want to play games? You want to play games?" and fired 8 shots. So they punched him. He then returned 8. Let me repeat. 8 shots. Thomas Baker, he returned. And the Hillsborough Court prosecuted, they opted not to charge Baker because he was standing his ground. And there was a case of 19-year-old Christopher Coote, who was killed by his neighbor after a dispute over walking his dog on his neighbor's property. When Coote came back unarmed to talk to 62-year-old Jose Tempanos about the dispute, Tempanos answered the door with a shotgun, stepped outside onto his lawn, and shot Mr. Coote twice. All these examples are examples where people had the opportunity to cool themselves down, which is the problem that I have with the stand your ground law. Because in all these instances, when an individual goes home to get a gun, or an individual says, I see him knocking at my door and I'm looking at the peephole and I'm coming out with a shotgun. In all those instances, America, in all those instances, that's premeditation. Because, just think about it. The Jeep pulls up, for example. Let's talk about the Christopher Arroyo case. Norman Borden saw the Jeep, went into his house to get the gun, knowing I'm going to come out and I'm going to use this gun to kill these gentlemen. Premeditation. Is that not premeditation? You thought about it. You went home, you meditated on the situation before you did it, and then you did it. Premeditation, first-degree murder. No one should walk. Point blank, period. And the fact that they could say, yeah, I killed that person. I was standing my ground. No, my friend, you weren't standing your ground. What you did was committed first-degree premeditated murder.